Um, it's nice to see everyone this morning. The coffee talk is an MSBA concept to keep us connected together, connected with the section and with the State Bar Association. We have a lot to cover today, and if we don't get to all of it, I expect we will be doing further coffee talks. But to start out, we felt we owed it to Richard Gins, to the collegiality of our bankruptcy bar, and to our bankruptcy section to honor and say a few words about the memory of Richard Gins. When I posted about the passing of Richard Gins yesterday morning, I referred to him as a bankruptcy legend. Many of the attorneys in this program, the younger attorneys, did not know Richard, but just about everybody back in the day before the Greenbelt Court knew him, because when you got off the elevator on Hungerford Drive, you faced Richard's office to the right. And he was there often. He was there when people were in court having hearings, working out settlements in the hallway outside his office and in his office. The first thought that came to my mind, and many of his era, is that Richard Gins was a character. He no doubt would be proud to be considered a character, but a very good bankruptcy lawyer and very well respected. The first person that came to my mind about saying a few words was Janet Mess. However, first I reached out to Augie Curtis to check with Steve Greenfeld to see if he wanted to do it. But Augie let me know that Steve didn't feel up to it at this time. And then eventually, through a circuitous route, I ended up with hopefully Janet on the call and with Lynn Cohen. I know that others might want to chime in also, but first, if Janet's here and Lynn as well, to say a few words, and then anyone else, and then we will get into the program. And again, we will cover what we cover and do another program if we don't get it all in. When this part of the program is over, I will introduce the MSBA and the rest of the program. So, Lynn, do you know if Janet's on?
I don't know, so let's find out. Janet, did you make it on? Well, doesn't sound like she did. I forwarded her the login information this morning, so but maybe she's never. This is my first time also using Google Meetup, so maybe she had a tough time downloading it. So anyway, so I'll start if you would like, and then if Janet joins, she can add too. I was actually really honored when you asked for me to say a few words about Richard, and I'm going to try and do this without crying, but it's going to happen. I actually didn't know Richard as long as many other people did working in the bar. I got to know him very well once I joined the Office of the United States Trustee, and I was just overwhelmed by Richard. To say he was a character was an understatement. But Richard had this, and maybe it's like an old way of practicing law. So when you were in the courtroom, he was a fierce advocate. But the minute you stepped out of that courtroom, he was your friend. And he would talk to you about your personal things, and you would go grab lunch with him. And I feel like we miss that a lot nowadays in the bar. So we're so into representing our clients that we forget we're people and that we're friends sometimes. And Richard had this way of reminding you that we were all people and we were doing our job and we could be good friends. And Richard and I, we had many adversaries together, but we were always really good friends through it. And I was joking around and saying, I remember so well that Richard would be the guy that it would be like a week before trial, and he would call me and he'd go, Lynn, why are you putting in exhibit number 2? He'd be like, well, Richard, I have to prove this or I have to prove that. And then he'd go, okay. And then 15 minutes later, he'd call back and go, Lynn, why are you putting in for 3? And, because it was Richard, you would tell him and you would talk to him about it. And I'm going to miss him so very much. But I have to share one story that I've repeated several times already. So I'm sorry if somebody's already heard it. But it's so Richard. As most people know, Richard was a huge college basketball fan, and he loved the Tar Heels, right? So North Carolina was his school. He was an avid basketball fan for them. So anyway, one day we had an adversary together against Judge Catleota. I mean, in front of Judge Catleota, and it was our first adversary in front of the judge. He was rather new to the bench. And when we were at a scheduling conference, and the judge said, okay, and he picks a date for our trial, and it was a date in early March. And Richard says, well, Your Honor, I can't make that date. It's the ACC tournament, and I always go to the ACC tournament. So Judge Catliotta says, okay, let's pick another date. So he picks a date in about 2 weeks from that date, and Richard says, well, Your Honor, I can't make that date. It's the beginning of the NCAA tournament, and I have to watch the Tar Heels. And Judge Catliotta says, okay, all right, well, we'll pick another date. And so he picks a date a couple weeks out from that, and Richard says, well, Your Honor, that's the Sweet 16. And if the Tar Heels make it to the Sweet 16, I just can't make this trial. So Judge Catliotta says, well, Richard, I don't think we're going to have a lot of difficulty there. I'm not so sure the Tar Heels are going to make it to the Sweet 16. Well, Richard was gasping for air at that thought. And so I actually had to agree on the record that if the Tar Heels made it to the Sweet 16, that I would not object to a continuation of the trial date. It was so Richard. And then he got a big laugh out of everyone in the gallery. And it was so funny. All of a sudden, he turns around to me and to the people in the gallery, opens up his coat. And his sports jacket that he was wearing was a North Carolina sports jacket. It had the North Carolina blue on the inside and the North Carolina insignia. And the whole place just erupted in laughter. And I was like, now that is Richard Gins. It's just, that is the story to say who he was. So, anyway, I just adore Richard. I think his loss is a tremendous loss to the bar. He had a way of making people laugh, of making the judges laugh, and to, like I said, remember the humanity of what we were doing. So, and with that, I just got an email from Janet saying that their office security is blocking access to Google Meet, so she won't be able to join us. For those that don't know, Janet actually started out as an associate in Richard's office. And in fact, Richard trained many people in the bar. And in fact, Judge Lip started out as an associate in Richard Gins' office too, like I said, as well as many others. So with that, I just want to thank you very much for giving me the opportunity to talk about Richard. Like I said, I think he will be missed. So.
Thank you so much, Lynn. And thank you, Richard, for this wonderful introduction and ability to share. It now looks like we have a group of 42 folks that have joined us. And if
Callie,
yes,
I'm sorry. I think Richard is trying to say something, but Richard, you're
Okay.
muted.
All right, Richard,
I'm
go
sorry
ahead.
to interrupt, but I could.
I just, if anyone else just
There we
wanted
go.
to make a comment before we get into the rest of the program. Is anyone? Okay, good. All right, Charlie, just before you start, I'd like to just introduce the program. So today's program is really a blending of three initiatives. And what we're trying to accomplish here is first for the MSBA to educate us on what they are doing for us now and what they can do for us in terms of what we're going through with the COVID and just the in general resources. Second, we have the Chapter 13 trustees, and they're going to be speaking about what is going on now with them and how we can best deal with the current conditions. And third, so that the people in the section, whatever they want to talk about, how they're coping, dealing with their office, their staff, their clients' cases, the bankruptcy system, and survival in general. We're going to have Shally, who's going to lead the discussion as far as the MSBA and their resources and response to the COVID situation. She's the director of the programs and membership support. We're also going to have Lisa Kaplan, who's the director of the Lawyer Assistance Program, and she'll tell us how the Bar Association can help us deal with the stress of the COVID situation. Being a lawyer is stressful enough, and especially for those of us who practice alone, the COVID situation is adding to the stress. We need to hold on and keep our mental health strong so that when the world starts getting back to normal and the bankruptcy world surges back, will be around to handle the surge. So let me turn it over to Shally for now. Then when that part of the presentation's over, we'll turn it over to the Chapter 13 trustees.
Thank you so much. Can everyone hear me okay? Wonderful. Well, I just would like to thank this wonderful group for getting together on this morning. It's wonderful to see so many of you today. I would just like to start by sharing with you, and some of our directors are also on this call, some of the efforts that the MSBA has undertaken since the COVID crisis began in March. And I'd like to start off by asking Director of our Legislative Programs, Richard Montgomery, to give us an update. Thank you, Richard. Richard, are you there?
Shally, it looks like he fell off. I don't see him in my list.
Oh, okay. Well, I'll go ahead and share then what we've been up to. And if Richard, if you're able to join us again, please feel free to fill in. But MSBA has been busy staying connected with all of you and staying connected with Maryland leaders to get answers, to understand what your concerns are. We have put together a lot of webinars, over 20 at this point, with a lot of our sections and members. We've held town halls with section and committee chairs and with some sections. And we've also had now some of these coffee talks that will continue through May. We have shared several questions with the Maryland Judiciary. We've also connected with the federal judiciary and the Governor's Office of Legal Counsel. And we've provided those responses not only to our members, but to the entire profession through our website and through our emails. We continue to connect weekly with the largest firms in Maryland to talk about how they're weathering the crisis and what the future looks like as COVID continues in 2020. We've also been working with the Maryland Chamber of Commerce as part of its COVID work group, and we have focused on the economic impacts of the crisis. We focused on advocacy efforts. We've been talking about a lot of the legislation and the loans that have been coming in. We have this dedicated website that we've been updating with a lot of original content and also pulling together resources to assist you as a practitioner and keep you up to date with the latest. And Anna, if you can jump in now and give us an update on some of the publications and communications.
Sure, you think after 8 weeks of doing this, I could find the mute button sooner. Thanks so much, Shally. So we have been putting out 2 e-weeklies a week in your email. You'll get one around Tuesday. We got one last night just to kind of keep everybody up to date on current information that's going on with COVID. Often we have been headlining those emails with information on the various jurisdictions in terms of court orders, updates from the governor, administrative courts, and other jurisdictions. So hopefully those have been helpful to you. On Fridays, we also added a new weekly roundup just to kind of cover some of the other updates that have been happening. Things have just been happening so fast. We realized that a once a week email with this information just wasn't timely enough. So we've been trying to do that twice a week for everyone to keep everybody up to date. Our bar bulletin this past month and in May were published digitally. We will be doing that just simply because we know that a lot of folks are just not in the office. There's a little bit of danger in terms of transmission of COVID on mail and things like that. So we just did not want to take the risk. So those have been published digitally. You can find the April bar bulletin up now, and the May bar bulletin will be coming out in about a week. Usually around May 15th is the date that it's published. And I want to thank this section and Bud Taman, I see that you're on especially. Thank you so much for always providing good content. We love to have that type of content from the section. We find it to be very helpful, and our best writers come from our members. So I appreciate you always having a submission for us. Our bar journal will also be published. I have the second draft layout today. So with edits from that should be published. Again, that'll be digital right now, just simply because of the mail issues that we're having. So we'll return that to a printed publication in our summer edition, but a digital edition should be out in the next 7 to 10 days.
Thanks, Anna.
You're welcome.
And I'll let Andrea, excuse me, Andrea Terry, give us an update about the webinars and learning opportunities. Andrea?
Thanks, Sally. Good morning, everyone. Thank you for taking time to join us for this conversation this morning. Our coffee talks have been well attended, and people are hungry for connection and information. Since this has all started in March, we've, as Sally mentioned, scheduled more than 20 COVID-related webinars. I think many practice areas were impacted in ways that they hadn't anticipated, and many sections have stepped up to really try and help their colleagues address just unprecedented situations that have arisen in their practice areas. So we've scheduled 20 webinars. We've had more than 14,000 viewers, both members and non-members, between participants in the live presentations and viewing the on-demands that we put up on our COVID website after the live presentation. So, as I said, there is really a hunger for information and connection. Sally or Anna also mentioned the free CLE. There's a coupon code out there for our on-demand catalog, and that'll be in effect until the end of June. So every Wednesday, a Learn from Home email goes out that has that CLE coupon code. It's also on our website, on our blog. And so we welcome you to sample some of our on-demand if you haven't already done that. Your section is starting a COVID-related practice series this month. May 20th at 1 o'clock is our first webinar. And so I thank Bud Taman for leading that effort as well. Really appreciate that. And I think that's going to be really well received. If there are topics that you think haven't been addressed that you think are important to your practice area, or not even substantive law related, Monday, for example, we did a webinar on what businesses have to consider in the way of public health issues before they start to reopen. So we're trying to cover the gamut of what might impact people's practices and their everyday lives from a very kind of tactical, logistical, and practical approach. So please feel free to reach out to me if you have any topics that you would like to see covered that aren't covered. And with that, I'll turn it back over to Sally.
Thanks, Andrea. Anna, if you're still there, could you give an update about the annual meeting and plans for the fall?
Sure, I'm still here.
On mute, not on mute.
As many of you have likely heard by now, we had to make the very difficult decision of canceling our annual meeting. So everyone has been notified at this point in time. One of our strategies going forward is that actually internally we have a meeting to kind of identify and start scheduling out how we can utilize many of the programs that were submitted to record them and add them to our on-demand catalog, just so folks can view over the summer at their leisure or whenever you'd like. So we'll start. I know that this section has submitted a couple of programs, so stay tuned. We'll be reaching out to you soon on working out how we can schedule and record those programs so that we can still get that valuable content. We were super excited for this year. We had over 80 plus substantive programs. We had numerous programs in practice areas. We had about 5 programs on consumer bankruptcy alone. So that was really exciting. So we want to make sure that we get that content out to you guys. So that's what we're working on now in terms of scheduling that out. We're also looking to create kind of a new program in the fall. And by new, it's going to be a new umbrella called the Legal Excellence Week, in which we would schedule some of our most popular individual programs. So we have the Advanced Business Law Institute, Advanced Estate Planning Institute, and some others. Hopefully we can get the Solo Summit as part of that as well. So it'd be a week-long content. And folks might attend for a day based on what's workable for them. You might attend for 2 days based on the programming. So that's something that we're working and developing. Right now we are searching for a venue and working out some logistics. So more information will come on that.
Thanks, Anna.
You're welcome.
We also continue to have publications, and we do have a few titles coming up. ESI is the next title, and we're still continuing to offer all of these in print and digitally on our site. Lisa Kaplan is our director of the Lawyer Assistance Program. Lisa, could you give us an update on your program?
Sure, thank you. First of all, I'm sorry for your loss. Richard sounds like he was a great person and very funny. I want to give you an update on health and wellness and the Lawyer Assistance Program. These are really, really difficult times, and we have a lot of information on the Health and Wellness COVID page. We have the tip of the day. I'm running a support group today at 2 o'clock. We're going to talk about resilience, so please join us. The information is on the website. We have some webinars on there. We did a midday reset, and that was a great program, and you can watch that at your leisure. We also have TED Talks on there and tip sheets and yoga. And there's a new tip sheet that was just written by an attorney on our committee about how he's managing his practice and managing the stress of COVID. So there's a lot of different information on there. There's hotline information and emergency information as well. But there's just a lot of great resources and tip sheets and a lot of help that can help you manage these difficult times. And then the Lawyer Assistance Program is always available to help you with any type of problems. It's free, it's confidential. It is a short-term counseling program. We have a network of counselors around the state. I am meeting with people either virtually through video or through calls on the phone. And so it is available. We haven't stopped helping people because of what's going on with COVID. And you can also make a referral if you were ever concerned about another attorney. Please call me and talk with me about it. You will not get them in trouble, but you may end up saving someone's life. We will reach out to them and make sure that they are okay. These are really, really difficult times. We also have financial assistance for anybody who is struggling to pay for their counseling, or they need treatment, they need to meet with a psychiatrist, or they need inpatient or outpatient substance abuse treatment. We are available to help to pay for that. So somebody just needs to get in touch with me and talk with me about that. The Lawyer Assistance Program is also available to all attorneys in Maryland. So if you have any questions, please reach out. Please take care of yourselves and let me know if I can help. Thank you.
Thank you, Lisa. And as I mentioned earlier, these are some of our advocacy efforts. And Richard unfortunately had to drop off the call. But we were successful in working with a lot of sections to bring about remote notarization and remote witnessing, and to obtain clarifications about administrative orders from the courts, as well as interpretive guidance that was coming out. And we were able to obtain new interpretive guidance as issues arose for our profession. Our Access to Justice partner has also posted its own website with COVID resources. And they continue to work with civil legal aid organizations. They're working on addressing upcoming funding issues and focusing on disaster legal services and efforts that they can provide to the community. So we are busy, we are here for you, and we're so thankful that you all are staying connected with us. We are going into our renewal season this month, and we would just ask you to consider the resources that you've obtained from us, spread the word, have other people join us as we continue to weather the crisis. We really are focused on helping to get all of you through this. So please reach out to us at any time and let us know how we can help. Richard, I'll turn it back to you now. And Doris, if you're there as well.
Thank you, Doris. I had to unmute the mic. Okay, the next part of the program, Robert Thomas and Becky Herr have been going through issues about what to do with deferrals with COVID and modifying plans and the CARES Act. And together with their staff attorneys, thought it would be a good time to discuss those things with us. And if you were on the call with Judge Catliota Monday, there's been some discussion of additional flat fees having to do with modifying plans, and that's in the works as well. But let me turn it over to Robert to go over the issues what's going on currently with Chapter 13s and in future.
Thanks, Richard, and thanks for the MSBA for putting this on. I think this is great. It looks like there's over 39, 40 people on, so I think it's a good turnout, especially for 8:30. Because I wasn't necessarily pushing for the 8:30 time slot, but it's fine, it works. One of the things that Chapter 13 trustees have tried to do is get information out regarding the process of doing 341s. I think right now, my office, we're doing it by telephone. Becky's doing it by Zoom. She has 2 different lines, so make sure you know that. She has, for the Zoom, there's 2 different ones. There's a line for Greenbelt and a line for Baltimore. So make sure you're following that protocol that's in place. All that information has been provided. It's on the court's website. It's been provided in the MSBA newsletter that just came out. It was provided in my newsletter. So just make sure you're up to speed on which trustee is conducting 341s and how they're doing it. I think it's been pretty seamless. The telephone's pretty easy. The dial-in number is easily accessible, and anybody that has a phone can get on. The 341s that I've had have gone pretty smooth. Creditors have been able to attend. And I think it's allowed some flexibility in the process. So I think it's good as we go forward. Right now, the remote 341s are going to be conducted through cases filed through July. And again, that's probably fluid as we go forward, but I would suspect that, as we get closer to June and July, we'll have more information. But I would assume that right now we're going to be doing remote for some time until everybody's up to speed in the courthouse and everything that's going on with the virus situation. We do have, I think we have Fred and Brian and Becky on. They can chime in too. But I think, as far as the 341s go, it's gone pretty well. The key part is make sure you get the documents over to us before. Make sure we have the photo IDs and social security cards. And I think that you'll see that the flexibility that's been provided to you and your clients is great. Becky, you have anything to add?
Yeah, no, I would completely agree. I think that people have done an amazing job of talking to their clients beforehand. If there are any problems during the actual meeting, you guys have been very quick to say, give me a second, let me talk to my client and get everybody organized and back on the call. So I really appreciate everybody working together. But I think they've gone really smooth. If you guys have any suggestions about, making changes, or if you guys are finding that you need to be on with Robert or Tim, will we have the same hearing time as one in my office, just let us know. We're trying to be flexible and make sure that everybody can make these meetings.
Yeah, and I think that one of the important things that I think is coming out of all this is just highlights communication between the Chapter 13 trustees and attorneys and working together. I think we are trying hard to communicate and to work with counsel to be flexible. I know their office is, and I think it's working pretty well. We haven't had any real issues. To touch on some of the big changes that I see that are going to come with Chapter 13s is from the CARES Act. I provided the information in the newsletter. The information is also on the website and on our website. So one of the big things that I see that's important is you're going to have clients that are going to be in forbearance agreements right now on their mortgage payments. And one of the nice things about the CARES Act is if you have a confirmed plan and if you file a motion and attach an affidavit, you can potentially extend the plan out to 7 years or 84 months. That's important because as your clients may be dealing with a forbearance, that could be 3 to 6 months of mortgage payments. Well, now they don't have to stress out about trying to come up with that money. They don't have to increase their Chapter 13 plan payment. You can go in and modify the plan out to potentially 84 months, keep the payment at the same level, bring in the post-petition forbearance payments, and that'll be a good way to allow individuals to not have the stress of trying to come up with a lump sum or adding on at the end of a mortgage payment, at the end of their mortgage term. It'll save them money, and I think it'll be, the accounting that we can provide. I recommend, and I think probably Becky would agree, is that the consents be that you pay the payments through the Chapter 13 plan. This avoids your clients having to pay the Chapter 13 plan payment, the mortgage payment, and now the consent payment. Those rarely work to me. It puts too much stress on the individuals, and I always try to recommend that they bring in the payments into the plan, the post-petition payments. That way, we can provide the accounting, we can make sure they're properly paid, and it avoids, the inevitable problem of your clients having to run into issues regarding the plan payments. The other important thing from the CARES Act is the definition of income. Your clients are going to be receiving those stimulus checks. They've accepted out as far as the income, the receipt of those payments. So we're not looking at them as far as being necessarily in the 13 as an asset, so to speak. There's exemptions that can apply. Obviously, most of the trustees aren't going to try to recover those payments, and certainly not in the Chapter 13. But you don't have to calculate them in as far as the income, and it's not going to be anything where we would look at as far as when the case comes up for confirmation. But I think the important thing is just looking at your situation for your clients. Becky and I are getting calls, emails saying, what do we do? When do we do it? Should we suspend payments? Should we wait to modify? I'll reference the court's order. It's Administrative Order 2010 addressing modification of confirmed plans and expedited treatment of Chapter 13 motions to suspend plan payments. That's an important order. You want to make sure you've reviewed it. Follow the procedures there regarding motions to suspend. We're reviewing them, but we're quickly within probably 48 hours filing, no oppositions. Becky, do you agree with that?
Sorry, yeah, I'm trying to get that done as possible. What I would suggest, however, is like Robert said, take a look at your case, because I don't think a motion to suspend plan payments is required in a pre-confirmed case. So I wouldn't waste my time. I just filed an amended plan that cures that issue. Also, if you don't have a wage order, I wouldn't necessarily do one either, because the administrative order put out by the bankruptcy court doesn't automatically modify the plan. So again, I think it's for cases that are post-confirmation and that have an active wage order in place. If your debtor's lost a job or isn't getting income, again, I'm not sure that an order is necessary. We would like to know that information. We're noting our file so that we know not to file motions in that case. But I think that some of the factors that I'm looking at as well, but we are trying to get the responses out as soon as possible. If a few days have gone by and you don't see a response, just let me know. It may not have or may have gotten lost in the emails that I'm seeing, but keep us updated.
And I know my office, we put a moratorium on. I'm not moving to dismiss on any cases unless the attorney has possibly reached out to us or there's been no payments for some period of time before. So your clients don't have to worry about a motion to dismiss, at least right now. As long as we get communication, we can note the file. I tell people that all the time. The best thing they can do is let us know. If there's an issue regarding payments or a problem that's come up or a medical issue, as long as we know, then we can note the file and make sure that we're not, pursuing anything that we don't need to at that time. So communication is key between the offices. And I think that, one of the things that we face is that, people are asking, should we convert? Should we do this? I would wait. We have maybe a couple more months. People should be getting back to work. And my receipts have kept. I think for the last month, I think we still received was over 2 million that came in. People are still dropping off payments at our office, even though we're closed. They slide them under the door. TFS is still being used. So I think right now they're kind of holding as far as a lot of people are still being able to make the payments. But we're providing the flexibility to clients so they don't have to stress and you don't have to stress. And we'll work with just about everybody to try to make these cases work and play out. But definitely, I think to me, a lot of people may disagree. Being able to extend the plans out can solve a lot of problems and a lot of stress for your clients they may be. I've recommended that attorneys file applications for additional fees. Generally, I'll approve them. And what we're working on with the Bar Association and a group of attorneys is trying to come up with an additional expedited no-look type post-confirmation a la carte fee listing, which will provide for potentially additional fees with a simple application. We revise the application, it's one page, and it'll deal with anything that may have come up that was unexpected related to these types of cases that are coming up. Just about everybody has been directly or indirectly affected by the virus, one way or the other. And obviously attorneys have additional costs, additional time. They spend a lot more time dealing with rescheduling 341s, handling things remotely. I'm pretty sure the court is aware of that. I know the trustees are. And what we're working on is trying to get either an amendment to Appendix F to deal with it during this crisis period, or a full-blown addition to Appendix F going forward. And we'll see what the court deals with that. But I know the court is receptive to looking at additional fees. And I think that the numbers that we have that have been circulated are more than reasonable. They're not going to be perfect, but what we did was we took them from a sample of across the jurisdictions of the average no-look fees that are being accounted for post-confirmation. And I would tell you that they're probably, what we put together is higher than some other ones. But my research shows that Maryland's in the top 8 as far as cost of living. It's high a lot compared to a lot of jurisdictions. So I wanted to account for that. So I think, definitely the trustees and the court is going to be looking at trying to get this done pretty quick so we can, efficiently handle post confirmation additional fees supplements. Becky, anything to add on that?
No, not really. I would say that I think the court is signing the orders pretty quickly. So if you did apply for these, court is still signing those in a timely manner.
Yeah, so I mean, definitely for attorneys, definitely look at that, and it'll be hopefully coming soon. But in the interim, you can do applications, supplemental applications for fees. Make sure our office knows about them, and then make sure too that you built it in so it doesn't affect any feasibility. So if you're going to be extending plans out, it's a good way to have it covered if you're going to extend out to 84 months, those additional fees. And then I'm also going to be proposing to the bench too that the no-look fee right now is based on a 5-year plan. My thought is that there should be an additional kind of representation fee for the additional 2 years, somewhere maybe $500 to $1,000, because there's going to be an additional amount of work that comes in for the 2-year representation. Phone calls, emails, things always come up. And so we're going to try to see if we can get that covered. So at least, it's built into if plans are going out to 7 years. So I think that'll be important, and hopefully we'll be able to get that through soon. That way on plans that are going to be extended out, attorneys are going to get additional fees through that period of time. A couple other things I would say is that confirmations, we're working on that. I know it's a big issue. I know that all the trustees are working hard to accommodate cases that are going forward. As everybody knows, and as the judge talked about on Monday, we have the district court order that suspended all hearings. And what that has done is, we have the 13 dockets, but, necessarily can we confirm cases or not on those dockets? And so we've tried. And a lot of cases, there's going to be cases that have been confirmed if they were pre-COVID and the objection period expired. We're going through and we haven't changed our processes as far as how we administer and review plans and get them ready for confirmation. We're still sending out the notices to creditors bar and to debtors counsel. We've got a proposal to the bench as far as trying to expedite that and trying to get some resumption of either a telephone or Zoom confirmation dockets to at least be able to say that we have a hearing. And that way we can either do podium calls and still move cases forward, because we're definitely aware that we want to get creditors paid, we want to get attorneys paid, we want the cases to not get log jammed and backed up as far as the continued docket. So we're working on that. Hopefully we'll have additional information on that in the next week or two. And obviously we'll follow up with anything onto the bar and let attorneys know. Becky, do you have anything to add on that?
Not really. Like you said, we're our cases as we usually would. We're confirming everything that we can or that we believe that we can. And if we can't confirm it, we're trying to get it in the best posture it can be so that when we get out of all of this, we can confirm a whole bunch. So I appreciate all of you guys working your cases as much as possible. Just know that we are trying to get these confirmed if we think that we can. But as Robert said, we're trying to work on processes with the court. And so hopefully we're going to have some more information in the next week or two.
Yeah, and I have seen a lot of attorneys use this time wisely, get those amended plans done, get those things ready, get any motions that you need to get filed and get them addressed. And I've seen it where amended plans are filed by the time I'm doing the 341 and definitely ready before confirmation. So I think you'll see that the fruit of your efforts will pay off as we can, once we can get them ready to confirm, we'll be able to get those through. So use your time wise, get those amended plans done, and then just keep in communication with us. Checks went out this week. I mailed them on Saturday. We're still working. 13 offices are still up operating, pretty much full go. We might be on, different time slots and things like that, but we're definitely been working through this whole process. The staff has been holding up. We've got to change some of our internal processes, but I think you'll see that it's, we might be a little bit slower on some things, but we're pretty responsive. You still have access to Becky and I and Brian and Fred and David and everybody in our office. So, continue to communicate with us, and we're working to make sure that we're helping and providing communication and confirming cases and getting money out. And that's one of our goals, obviously. Becky, anything else?
No, I think that you covered it. We sent money out last week, and we're continuing to do it as Robert said. Our main focus is to get money out to creditors, to you guys, to make sure that these run as smoothly as possible. And I think that my office is doing a good job. As Robert said, we're here, we're working full time. So if you guys need to get a hold of us, email is probably the best way. We are in and out of the office on a weekly basis. So hopefully we'll be able to get back to you for any questions you guys have about your cases.
Can I ask two quick questions?
Sure.
Thank you both. And thank all the people who put together this conference. The first, is the 8-year period, the 84 months, only for cases where plans have already been confirmed? Or can we extend plans for cases that have not yet reached confirmation?
Right. If you read the statutory interpretation that I read it's confirmed plans. Now, I don't know if anything will be changed from that or anything going forward. I questioned why it didn't apply to any cases that were already filed. And certainly, if there's a case that's filed and it's been affected, you can still file your motion. And the court may interpret it and say, yeah, I know we had a couple cases that were going to come up for confirmation that because of when the court shut down, they didn't get confirmed. And arguably, maybe those are ones that could come up and be asked to the court to see if we could extend the plan term out. But strict interpretation of the statute says confirmed cases. But we'll see if anything changes from that. But again, I think there's other options too. You can try to see if you can need more time. You could potentially, under the Fourth Circuit, extend the plan, run the term from confirmation. There's some things to do there. Talk to each trustee. We've posted, I know Dan Press and I and others are on the listserv have posted options regarding that. So there is some flexibility as far as trying to work it through. And I think, everybody's going to be receptive to trying to work with people because this thing just happened. It's a national crisis. We can't blame anybody. We're just trying to work it through. And I think that there's going to be a perspective of, hey, if this needs to happen and we need to make it work for people, then let's try to see if we can get it done if there's no objection. So I think, hey, it's always a possibility.
I agree with you. I read the statute the same way, that the 7-year, 84-month period only applies to cases where the plan had previously been confirmed before the crisis began and the administrative orders were issued. That brings up the second, it's not really a question, it's a comment. I had a case many years ago, In re Kotsis, Kotsis, And Judge E. Stephen Derby determined that the 5-year period for a confirmed plan began when the plan was confirmed. Not when the case was filed, not when the plan was filed, but when the plan was actually confirmed by an order of the court. So if I take the holding in COTSIS, K-O-T-S-I-S, and apply it to what you and Becky have just said, this 7-year, 84-month period would begin to run for a modified plan from the date it was confirmed. And that may very well be a longer period than 7 years.
Yeah, I mean, it could run out longer than the 7 years, depending on when confirmation was. There's also a Fourth Circuit case in Ray West. Now, some of the issues that come up regarding that is because those were pre-BAP-CIPA, the 05 amendments. But I think it's still good law, and I think that, as trustees, we'll look at it, and if there's no objection by any creditors and the court is willing to enter an order extending it, then I'm open to look at those cases to work with people to make things work. I mean, I don't want to deny people the ability to reorganize, especially going through this if they had setbacks regarding work or the forbearance on mortgage payments, car payments. I mean, I think in the end we want every case to be successful, and I want debtors to come out and get a discharge and not have to be overly stressed and panicked and worried about their house and things like that going on with everything else. So
that's why we love you.
To me, we'll work with you, and I think Becky will do the same. Their office is great. They're going to work with you, and I think they're open to review things. We're almost on the same page on a lot of things. We talk, trustees talk to Tim, we talk to Becky. We've done calls, we've done conferences, so we're on communication. Everybody's on the same page as far as working with people. So I don't think you're going to see any resistance from our offices. Anybody else have questions, issues?
Nice collection of sports memorabilia behind you.
Oh, thanks. But the key is and one of the things that I put together in the newsletter was some of the wellness stuff, because it's important. I think I haven't seen another attorney since March 13th as far as in person. I've pretty much gone from the house to the office and work out in my garage, and that's about it. But doing these is important. Talking, picking up the phone is important. Talking to the other attorneys, seeing the other attorneys, and just making sure that you're staying focused and not panicking, and using the MSBA resources, because these are stress. It's stressful. Is the phone going to ring again? Is there our cases have dropped? I mean, we're talking 45 cases, I think, for April that I think I got as far as assigned cases. Now we know that it's going to pick up. But as far as, counsel, we understand. And so, if you need to talk, if you have things you need to go over, issues, pick up the phone, give us a call if you want to schedule FaceTime or conference or Zoom or however. But, we can help you, and we'll try to help out as best we can. But use the MSBA resources. There's no reason to get overly stressed and panicked. We're all in it together. As Mark Neal said, I think the court has done a fantastic job. The court office, the U.S. Trustee's office, the judges have all done a fantastic job, given what we've had. Nobody was prepared for this, obviously, and the court and the U.S. Trustee's office and the clerk's office has done, I think, a great job as far as working through this as best they can, and providing information and communication, and really being flexible as far as working with attorneys, working with trustees, and allowing these cases to continue to go forward and providing resources to attorneys. So definitely take advantage of the resources that are available, and don't be afraid to pick up a phone and call people and talk to people. I mean, I think it's great. I think this is great. This is why I was trying to push to get something going. We get to see each other and talk, and if you have questions or issues, it kind of brings us back to some reality once we come out of this. Anybody else have questions, issues? So I think going forward, we're going to continue the remote 341s. I think we're going to get some guidance on confirmation hearings. Again, we're still trying to confirm cases. on a case-by-case basis. I think we'll have some more information regarding confirmations in the next week. And then that'll help get cases reset for dockets. And again, we'll move through the cases the best we can to recommend confirmation. I think it's important on your part as attorneys to make sure you get those amended plans filed, review the claims, get them ready, proofread them so that way when we get them to confirmation, we can get them confirmed, and then we can get them set up and processed on our end. The offices, we just don't want to get stuck with trying to process 900 cases in 1 month, because we want to spread it out, and we want to make sure that we can get the orders up to the court, and then being able to set the cases up to pay out within a pretty quick period of time. 341 remote access. People have asked, is this going to be the new norm? I don't know. I do think it's going to provide some flexibility, because my recommendation on 341s is going to be, if you're sick, if your client's sick, no reason to show up at the 341. If there's a creditor there, we now can do it via Zoom. We can do it via telephone. We can still conduct a 341 without having to have anybody come down that maybe has flu-like symptoms. I do think that the 341 rooms will probably be reset. I'm assuming that the U.S. Trustee's Office will work with the trustees as far as once they decide if they're going to resume in-person 341s, having the rooms set up, maybe spreading out 341 schedules with the trustees so we don't have, a large waiting room of people, and, different things. So I think you'll probably see some movement on that, in the next couple of months. Right now the district court order goes through June. We're kind of hoping that order doesn't get extended again. And if it would, I think the court would then be prepared to probably do separate orders. But we're hoping that won't get extended, and then things will start to resume as far as the normal dockets. My recommendation is, if you got a motion or anything that you need to file, you can always file a motion to shorten the time period. Just make sure you file the procedures pursuant to the bankruptcy court orders for service and things like that, and make sure that there's no issues regarding that. And you can still probably get things through. I know the court is aware of the confusion. I know, and regarding different dates and extensions, but I think when in doubt, if you need to shorten time, try to get the time shortened. And then you work through those processes as we go. Anybody else have questions, issues?
Robert, this is Mike Wolf. Brian Tucci has been hard at work setting up the program with the court, and he's on, I think, and I think that we are tentatively scheduled to do another session with the Chief Judge and the United States Trustee on May 26th at 1 p.m. So if there are new orders that come out, we will try to press the judge to give us his interpretation of what they mean.
Yeah, and I think the one that was held Monday was great. I think it was, attendance was high. Over 150 people, and I thought it was good. I think Judge Caliotta's done a great job. He and Mark Neal and all the judges have been extremely busy trying to coordinate things, and I think they're moving as best they can under the circumstances, along with the U.S. Trustee's Office. So I think that was really good, and I think it'll help to have another one.
Let me also ask, when Brian and I tried to put this together, we had over 150 people that RSVP'd and participated, but we got very few questions. And whatever questions we got, we synthesized and then presented them to the judge. No questions were really rejected by the court. So I think the opportunity, again, will be to ask those questions. So I would urge everybody to follow whatever email notices come out from Brian and send in those questions, because within the confines of the time frame, I will try to ask the judge, and he's been very amenable to answer any questions we have. If he hasn't said to me, no, I don't want to discuss that. So I think we're in good shape.
And I would add too, even if you just have an issue or a question, the judge referenced the ad hoc committee. You can circulate those questions to the attorneys that are on that. Get them to Mr. Wolf. I think that if you have something that needs to be addressed in before that, or, we can then look at it. We may be able to help, or, they have we have weekly meetings, and so we could bring it up earlier if there's a problem or issue that you've seen. We're looking at this stuff the same way you are, and underneath a full work schedule, and so sometimes we don't always see everything or recognize something that might be affecting a different group. So my recommendation is, if you see something that's kind of different, or if you have a question, bring it to our attention. Then we can at least look at it or refocus on it, because we're just trying to process as much as we can on a daily basis.
Robert, I have one. I know you, Becky, take all the documents electronically. I physically had to go to get documents packaged so that they would be sent to Tim. I don't know if Tim's on this call, but Tim's still not taking documents electronically, and it does cause people to go out of their homes and have to deal with post office or going back to their offices. So in your Chapter 13 meetings, I would think if you could get a consensus that documents can be delivered electronically, that would be very helpful.
We'll talk about it, and I think, I think each trustee is going to have their own method. And sometimes, there's efficiencies that I think can be put in place with enough security to avoid any, hacks or anything like that. But we don't want people out making copies and out and meeting with other people. The whole point of the remote access and things like that is to keep people at home, keep people safe. And so, I think, we can talk about it, see if there's other avenues or alternatives that can possibly work, maybe a dedicated server, or, we use our portals through our software, and, sometimes there's a blip or two, but, generally people can get them through. When in doubt, you can always email them to me. Our email's secure. We have 2 firewalls. It's encrypted. So, I'm pretty confident on our end. I've gotten photo IDs and social security cards texted to me during the 341, which is fine. Hey, if I can get them and see them, it's great. But just, be aware, if we're doing 341s, I'm not always paying attention to my phone or seeing what's coming up on the email. So if you can get them to us in advance, that's helpful. We know, the trustees know, and as far as being a 7 trustee, that it's not easy. This isn't like, nothing's going to be perfect, and certain deadlines and getting the information with trustees is always going to work. So, we have the flexibility built in. I think all the trustees do. I think they're trying to be as flexible as possible. We're just trying to do our end, making sure that we have the photo IDs, making sure that social security numbers do match, so we keep the integrity of the system, so we don't have any issues with any fraudulent filings or things like that.
Well, the question, as you know, wasn't directed to you.
No, I understand.
You said that you do speak together as a group.
Yeah, we do.
In your next group meeting, I think it would be helpful if we could have a vehicle in his office that we could actually fax or scan an email, preferably. But I was told we couldn't do that, and we had to actually physically go to the post office and send a package. So it was not the best way in these times to deal with it.
And we'll inquire about that. And I think we can, maybe we can do is we can help put together, we can do a survey of all the trustees, 13 and 7 trustees, and see and have them provide us with their recommended process for supplying 521 documents. And then we can maybe, with everybody's approval, post that either on the listserv or through a newsletter or on the, on the court's website or something. That way we can get more information out.
That'd be great. Thank you.
I think that's a good idea. Somebody made that suggestion on Monday in the meeting.
It was one of the questions to Gerard, and he said we leave it to the trustees. So, and as trustees, we try to be uniform to the degree that we can.
Right. But I think at least having a list out there of how everybody gets their documents, I would think it'd be particularly helpful. So.
Yeah, so we can work on that. So we'll get an email out to the trustees and have them get their recommended process, and then we can put that together and get it posted and listed somewhere, and then get it out to everybody. That way they know that they have a uniform place to look and find out for each trustee. And then it's just important that if anything changes, they just update it.
Thank you.
Sure. And then the committee will be working on the proposal on the fees. And we'll provide an update on that as soon as we submit it to the court and work with the court on as far as getting something done, whether it be either a supplemental Appendix F or trying to push for maybe a long-term Appendix F fix as far as post-petition fees. I would say that Maryland's fees are, the no-look fee is pretty good. Comparatively, I think we're like probably in the top 10 as far as no-look fees. And they do get adjusted every 3 years. So the base fee, I think, is okay. I would compare it to the Eastern District of Virginia, which I think is at $5,434. So we're pretty close to that. But I think if we can get the post-confirmation additional fees a la carte, I think that can help, because there's a lot of work that comes up on cases that, especially now, that maybe nobody contemplated. And the trustees know, we know that a motion to sell is while it may seem like it's simple, it's not. I mean, I get the urgent emails, calls from the title company, calls from debtors counsel, signing of orders, reviewing the HUDs. It takes a lot of time, I think we understand that those fees aren't actually captured in the no-look fee. So I think this is going to be good, and I think that attorneys will appreciate the additional fees for the additional work that they do, because we know. I mean, I know, I represented clients for years, so we know that the additional fees that encompass on dealing with all these extra motions and that come into place. So we're going to definitely be pushing for that. And I think you have the backing of the trustees. So I think that'll be good. I think we're in a different climate now. We have new chief judge, new judges. So I think it's definitely going to be something that's going to happen, pretty soon. And file cases, 13s. I mean, get them ready, get clients ready. I would suggest, if you've got a client list, old clients, send email blasts and letters out. See, because everybody's affected by this. To avoid, a forbearance or trying to come up with a lump sum or extending their mortgages out. This is why 13 is there. If they've got evictions, if they've got things like that, they can all be covered in Chapter 13. And so I really think that this is why 13 is in place, is to deal with situations like this. I was very happy to see with the CARES Act extending the plans out. Not every trustee might agree with that, but I think it's great. I mean, so your clients don't have to come up with more money. You can extend the plan out, keep the payment at the same amount, and extend it out so they're not more financially burdened by, the 6-month forbearance. I think it's, there's definitely a lot of flexibility that's built in with Chapter 13. And I think, definitely use it, especially for taxes. More now, you'll see it even probably as we go forward, is the priority taxes, but definitely look at the 13s. I think it's definitely can provide a lot of relief, a lot of flexibility for a lot of people. And I think now more than ever with the CARES Act, I think there's definitely going to be additional benefits that clients can receive as far as if they're in a confirmed plan. Any more questions, issues?
This is Shaoli again. I just wanted to let you know there have been several comments in the chat function, and it looks like a lot of you are having discussions, and Brian, looks like you want to take some of these questions forward. So thank you all for also participating in the chat and moving things forward that way.
And if anybody wants to bring up the questions from the chat, that's fine, because I'm not going to pay attention of like all the stuff.
Thanks. It looks like Brian is collecting those. Is that right? We'll make sure.
Okay.
Okay. I would like to thank Robert, Becky, Shaoli, Lisa, and Doris for participating in this. And if there is any follow-up from anyone, we will be doing this again. I think it was a good idea, like I said in the beginning, and like Lisa and Robert reinforced, for us to be in communication with each other and support each other. I would suggest that maybe you respond to either my post last night or put up your own post. If you have any follow-up from today or additional topics that you would be interested in having a meeting on, either with our section or with the Bar Association or any other issues that come to mind, because we still got some time left in this situation. But thanks again for everyone. Shally, back to you.
Thank you, Richard. And it's clear from today's turnout and the conversations that there's still a lot to say, a lot to discuss. So we certainly will plan to host another coffee talk with all of you, another forum to get together and maybe hear some more perspectives. So thanks again all for joining, and I hope you have a good morning and rest of your week. I would like to turn quickly to Andrea Terry, who'd like to recognize some folks on the call.
Yeah, thank you, Shally, and thank you everybody who's remained on the call. It just occurred to me that at the top of the hour, when we were talking about programs and publications, that I didn't raise the new book that Mark Kivitz and Jan Berlish have written for the MSBA with the help of Tom Nielsen, and it is on judgment avoidance and lien stripping, and it actually goes to the printer next week. So we're very excited about that, and I know Mark is on the line. And I just wanted to thank your colleagues there for putting out a brand new title on a topic that we haven't addressed before, and it's been a long time in the works. And Mark, I really want to express our thanks and gratitude for all the work that you and Jan and Tom have put into that project.
Well, that's quite unexpected and very kind of you, Doris. So thank you.
All right, take care, everybody.
That was
all.
Andrea, Mark, but that's okay. And just before everybody hops off, this is Doris. I just want to let you know that for the people on the phone, you don't have the option of seeing the chats. When we post the link to the video, I think we can also post a link to the chat box, questions and comments that were being made. So you won't feel like you missed it all then. Other than that, thank you very much, and we'll see you all again very soon. Take care.
Thanks, everyone.
Thank you, Andrea.
Somebody else have any other questions while we're still on?
Why?
We're here. I mean, if you want to ask it, ask it. I mean, let's talk about it while we got everybody on. If we can still do that, I mean, I don't have a problem staying on. If people have questions, because I haven't looked at the chat. Brian and Fred and David and whoever else is on can chime in too. I mean, I didn't mean to clog up all the time.
Do you think there might be a form of motion that might be posted to the court's website or to the Chapter 13 trustees portal that we could access for
we did work on I think a form motion to suspend payments that I think all three of us have kind of signed off on. We can post that. I have a draft of a motion to modify under the CARES Act. It's pretty straightforward, but we can, that hasn't been circulated, and I can provide a draft of it to people, but it does cover what you need under the new administrative order that came out regarding that. And the key with that is really just, referencing the statute and referencing and having an affidavit. And again, it's pretty broad, either directly or indirectly affected by the COVID virus. So I think, it's a pretty broad look. To me, just about everybody's been affected one way or the other. And so, I think if you have an affidavit and, it's presented properly, we shouldn't have any issues moving those simple term modifications out. And it can be a pretty simple process.
Hey, Robert, it's David Grossman. Good morning. How are you?
Good. Good. How you doing?
Good. Question. This hasn't happened, but it just popped into my mind. So if someone pre-confirmed Chapter 13, if somebody requests a 6-month forbearance, would that cause any obstacle with getting a confirmation and like the signing of a pre-confirmation certificate if they haven't made mortgage payments pre-confirmation?
Well, one of those, the problem with that's going to be is we have the issue of whether or not they're current when they come up for confirmation.
Right.
And, I think, it might be better to, in the amended, do an amended plan and list out the confirmation payments inside the plan. Because we just don't want to confirm it and then a month later you're going to be looking to modify the plan out. But again, maybe that's the way to do it. Because we haven't dealt with it yet. I think we got to kind of work our way through it. But if you have a recommendation or a thought or an idea on how to deal with it, we can look at that. Obviously it's going to be coming up on issues that, the clients aren't current on a, mortgage payment or car payment before, and can you file a PCC, or do we need a modified PCC put in place? That's a good idea. Maybe we need to look at that so that doesn't hold up cases being confirmed. But I think the mortgage companies are going to be filing the notice of the forbearance agreements.
Yeah, I've received quite a few of those in the last day or two, but these are all in older cases that have already been
confirmed.
So yeah, we'll work through it. We'll figure it all out.
So definitely. So when I see those, I have emailed the attorneys on those and kind of put them on notice that, and I think they've all agreed on the creditor side, because I said, like, if there's going to be a forbearance or any consent order, I've kind of said, hey, I want those payments through the plan. If there's going to be a consent order, and I think they're all in agreement on that. Modify the plan, extend the term out. Doesn't have to go to 84 months. Maybe you only need to go to 66 or 7 or 68 months. But because I don't want to have your clients be put in a position where they've got that 3 consent order where they're making a mortgage payment, making the consent order payment, and trying to make the plan payment. They're going to need a little bit of a time to get back up to speed if they've been on unemployment, as far as getting their finances back in order, internally. And so, we want to account for that, because if they've stopped and they haven't gotten paid and all of a sudden they're, the unemployment may be delayed, we want to give them a little bit of room to get back up to speed so they can, successfully make all the payments they need to make. So we need to probably, work on the communication on that side and building that in. Anybody else? And I would assume that once, like, the courts, the state courts start to open up, it's going to get busy. And you're going to see probably, because, right before when it hit, there were going to be foreclosures coming up and things like that. Those will all start possibly back up. And so, I think you got to be ready be able to handle the additional cases internally and in processing cases. So while it's been a little slow now, I think you got to kind of gear up for that. What could be coming, at the end of the summer or fall, as far as, new filings and, just really marketing it. This is, Chapter 13 is great to handle all these issues that are going to come up regarding evictions, regarding foreclosures, regarding forbearance agreements. There's no reason to extend a mortgage out 5 more years and paying double when you can have those 6 months put into the plan and the cure and maintain provisions. So there's definitely so much benefit that goes unnoticed in Chapter 13, and the flexibility.
I'm sorry, Robert, there's also another message in the chat box from Will Grafton. What about pre-confirmation plans? Can you see the chat box?
Yeah, hold on, I'll pull it up.
Or Mr. Grafton, you're still on the line if you want to go ahead. Your mic is open.
Okay. Yeah, so we have a couple cases where they're pre-confirmation, but we need to extend them out a little bit further than 60 months. So we wanted to start the term of the plan at confirmation, but the form plan in paragraph 3 doesn't really allow for that. So without modifying the form plan impermissibly, how do we accomplish that? You
can kind of modify where the adequate protection, the varying payments. You can, essentially have, you could do from months 1 to 5, say the lump sum amount, say $3,000, and then $600 a month for 60 months post confirmation. Now you might have to alter that a little bit,
right?
But I think that the couple cases that we've worked on with the court on more complicated ones, we've gotten those through on the confirmation order.
Okay.
And I think there's definitely there's ways to do it. And Becky, I mean, they might do it differently, but there's ways to do it with the varying monthly payments to do that.
Yeah, just generally there's a prohibition against modifying the form of the plan.
Well, but you could also make it a special provision if you check the box in 1.1 and highlight it as the special provision 2, it covers it. I mean, we're not talking about a drastic change to or adding additional language.
Right.
Basically just the, reworking of it.
Okay.
Or 3.4, under there, you might be able to slide it in. So there's definitely, I mean, I think I've done it more under the dealing with the varying payments.
3.4 might be a better option.
But, highlight it, let us know. That way, if we need to suggest anything on it. But I know on the complicated cases, bigger cases that we've had, we've worked it through with the court and gotten orders confirming based on that type of language. And, I think it's possible. I mean, I think it's, the Fourth Circuit case in Ray West is still good law. And it can, at least give people that are, the feasibility. Sometimes too, look at, if there can be a lump sum, or I know it's kind of questionable and not everybody likes lump sum provisions, but there's, you can either add in additional tax refunds. You could, look to see if there's any step ups that could come up that would help paying off cars, or if they could have access to equity that may be coming in. There's, different ways to make it work. I just did a case the other day for Salisbury where, the funding is going to be a little bit short, but there's a personal injury case pending that's pretty good. And so, the idea is that they're going to dedicate some non-exempt or some exempt proceeds into the plan to make up for any feasibility issue. And it's a wait and see, but we've talked to personal injury counsel. They think the case is pretty good if it wants settled. So I think there's, if there's plan provisions that are put in place, it definitely can give some flexibility and monitoring, as long as everybody's on the same page. And there's, I try to put in some of our plans, they'll update us every year or 6 months regarding the personal injury, and that way we can be sure that it's properly, accounted for with the plan. I mean, sometimes you just gotta get creative, and run things by us and see what we can try to make work, and kind of think outside the box on, getting to a point where, hey, it might be a problem now, but maybe there's something down the line. Because like I tell people, I don't have a crystal ball. I don't know what, we don't know. We didn't know that this all was going to hit this year regarding this process. And so, I think, as long as we can have some assurance that it's going to happen, and documentation that may support that, and a plan provision, I don't see why, if there's nobody else that's objecting to it and the trustees are satisfied, then we can recommend confirmation why we can't push it. But that's just me. I don't want to speak for everybody else. Anybody else? Anybody else have questions? Anybody else seeing any issues that they're seeing, or problems, or things they want to bring up, comment on, or what we can do better or help you guys on?
If you could tell me how to get my clients to get me documents. How poor some of these people are at technology. Even just using a camera on a phone.
Yeah, well, I think, though, the good thing, I mean, if there's anything good that comes out of this, is people are going to have to be much more adaptable to change in different processes and using technology. As uncomfortable as I was on trying to go on Google Meets, I figured it out last night and had to figure out the right browser and things like that. You just got to work your way through. But I think, more people are going to adapt to Zoom as far as, and, emailing and scanning documents. There's scanning features on phones. A lot of the printers that you can get now, they're not overly expensive, have easy scanners. The Fujitsu scanner is one of the best, and it's easy. basically, I can put the documents in and they scan front and back. I don't have to do anything. It goes right into a PDF.
We've got those for everybody, you know.
I mean, those are definitely one of the best scanners that I've seen because it's, you know, for me, I'm not overly technology savvy, but I know how to work it, and it's pretty easy. And you take advantage of some of the technology that's out there. And then with clients, you just got to, I mean, I used to always just full court press them, call, email, you know, and really get them to get this stuff in so we can get things processed because, you know, as everybody knows, you don't want the last minute, you know, the last minute emergency or urgency. And so I was always just pressing the client, look, if you want us to get it filed, we need stuff now. So however you got to get it to us, you know, we don't want you out driving, but, you know, maybe get them, go to a place and get them scanned in or have somebody help you scan them in and get them over to an email form. Or if they're, you know, a lot of the tax documents, they might have them from an accountant that the center will send over email with a, you know, you can send it over to us or send it to you with the code, you know, just a password to get in. We've had debtors do that before. Anybody else? Don't be shy. Brian or Fred, are you still on?
Hey, Brian is on, and I do not see Fred any longer.
This is
But
Shelley.
Brian's muted.
I don't see any other questions in the chat.
Okay.
If anyone has any other questions, I think we'll just take another minute or two. And as we said, we'll continue these and we'll have another session in the next couple of weeks.
I think Bud has a question.
What was the name of that scanner again you were mentioned?
Can you repeat that?
What was the name of the scanner that you?
Oh, Fujitsu, the Fujitsu scanner. Send me an email, Mr. Clark, and I can get you the descriptions of it. But they're one of the best. I think Amazon. There's different versions. You don't need the $1,000 version, but there's a couple that are in the $299, $3 range. But it is the easiest scanner. It scans front and back, right to PDF. All you gotta do is put it in the slot, and it goes right through. It's one of the easiest, and the quality is really good. But I can give you the descriptions that we've got for the office.
Thank you.
Because it makes, when you get the 521 documents, you know, you can just basically, you know, take the tax returns, put it in the feeder, scans right to PDF, front and back, highly legible, and, you know, then you can put it in your file and send it over either through the portal or to however the trustee gets their 521 documents. You can put in pay stubs, you can put in cards. It doesn't have to be a perfectly sized piece of paper. It'll basically scan anything that you put in. They're definitely, it's really good. It saves a lot of technology issues that may come up. And then we'll work on getting the list together from all the trustees as far as their preferred 521 document process, and we'll try to get that circulated hopefully in the next maybe 7 to 10 days.
Thank you.
Sure.
Well, it looks like Bud finally got his mic open, but I don't think his sound is working. So, but I can work with you offline at a later date, at a later time today, if you'd like, and see if we can troubleshoot that. I'm happy to do that with you.
Anybody else? Yeah, but again, feel free to email me, email Becky, email their office if you have questions, issues, and then we'll work with getting another one of these sessions. I think it's good. I think it's a good way for people to communicate and to see people and talk, and it's an avenue for communication, which I think is good.
Great, thank you so much. for joining us and for this wonderful discussion. We will be sending out a summary and the chat as well, and we'll keep everyone updated about the next session.
Great, thank you.
Thank you all.